We got Monday. 30.
34 to 125. Are supposed to be listed after 2 weeks.
Okay.
We have urgency is that the petitioners are not getting their compensation amount.
Monday.
Highly placed.
Wait, please, Your Lordship. Lordship, I beg to mention for a listing of the rate appeal. It's a fresh matter. The matter pertains to compensation of land. So Lordship may kindly allow it to be listed on the 18th,
Well,
13th, on Friday.
Monday.
Lordship. Wait, please, Your Lordship. Lordship, I beg to mention an IA for listing, Lordship. Lordship, notice was issued to all the respondents, but in the order it has inadvertently it has not been reflected that notice was issued to respondent number 8, Lordship. Lordship.
Okay. 18th.
Lordship, Friday, Lordship.
Friday will be difficult. Okay, Friday.
Friday. Degree of bench.
Item 1, orders.
May I please? We have to file affidavit final. So
You have filed your affidavit?
Yes, we have filed. From time to time, affidavits are being filed.
No,
I
the
think we have-
last order.
Last order was of 26/5/2025.
Yes.
6th May.
You're supposed to file a
We have filed it. Lord.
detailed report.
Interim, we have filed, and to that they want to file a response now.
yes, ma'am.
Okay.
2 weeks time. Ma'am.
When did you file it?
Yesterday morning.
Yes. The
Total.
what page did it is? It's on
In
record.
terms of the order dated 26/5, we have filed it
The last
yesterday.
one. Okay, Mr. Recycle Advocate General, Assam. Submits that he has filed an additional
Additional.
on yesterday was
10th.
June 2025. We used to verify Mr. Someone. Mr.
Yes, you are. Ma'am.
S. U. Ahmad, Learned Counsel. For the petitioner. Praise for how much time?
2 weeks time. Ma'am.
2 weeks time to file reply to the additional affidavit filed by the respondent.
What is state of all the, I think all the response.
Yeah.
State respondent procurement account.
By the state.
My lord, we have to file affidavit, not reply, my lord. Not reply, my lord.
Okay, file it, affidavit, huh? Okay, then you say, Mr.
I'm appearing for all the 4 respondents.
Praise for 2 weeks time to file an additional affidavit.
Yes, ma'am.
Praise Allah, please.
Not so.
Hello.
Item 10, orders.
This. Oh, okay.
Wait, Vigilance. Lord, we have filed an IA. Now, 2 posts has been advertised. No?
Yeah.
If your lordship kindly comes to the IA, before that, if your lordship would kindly come to the writ petition, page number 32, the earlier advertisement.
Yeah.
It is at page 32. Sorry, not 32. Page 34. The earlier advertisement in respect of grade 1, online applications are invited. So-and-so from practicing advocates for appointment of 1 vacant post of grade 1 of Judicial Mizoram Judicial Service in the scale of pay of so-and-so. Now kindly see the last date of submission of application was 24/6/24. Now, if your lordship should kindly come to 2.3. Must be practicing as an advocate in the courts of civil and criminal on the last date fixed for receipt of application and must have so practiced for a period not less than 7 years. So this is in tune with Milord 229(2). Now Milord will kindly come to the impugn advertisement which you have brought on record by way of the IA at page number 14. Page number 14, Annexure B.
Yeah.
Online applications are invited till 5 p.m. from the practicing advocates for appointment of 2 vacant posts of 1 existing and 1 anticipated. Now, existing in is perhaps the one in respect of which I am selecting. Now, my lord, please come to 2 and 3 and 4. Must be a practicing advocate in courts of civil and criminal jurisdiction for not less than 7 years, as on the last date fixed for submission of online application. This is same as we did the earlier. Now, this is a new thing. Must be a practicing advocate also at the date of appointment in terms of judgment in so and so. So, my lord, the advertisement itself carves out a distinction. That means what we are saying all throughout is correct. Now, my lord, this Dhir's case, in Dhir More's case, my lord, the rules of the separate states, my lord, provided that you should be not only a practicing advocate on the date of application, you should be also practicing advocate on the date of the order of your appointment. But in our case, Mizoram rule says otherwise. Please come to the Mizoram rules, my lord. It is at page 62 of the writ petition.
Page
62. And the rule 9 is at page 64. Rule 9, Miller. Method of recruitment, qualification and age. In respect of each category of the cadre specified in column 2 of the table below, method of recruitment and minimum qualification, age, limit, etc. are shown in the corresponding entries. Now, please come to that table, my lord. District Judge, if your lordship kindly comes to the qualification and age limit, 2. Must be practicing as an advocate in the court of civil and criminal on the last date fixed for receipt of application. So, my lord, Dhiraj Moore's case, where the rules were different. Now, my lord, all that I am praying for is in the main case, notice has been issued. Notice has been issued. Now, my only prayer is, my lord, either your lordship will have to protect me in respect of this second advertisement. Either one post should not be filled up, or it would abide by the result of the writ petition.
let it be,
Otherwise, my lord, my writ petition becomes infructuous.
let it be subject to the outcome of this.
Well, I make my submission. Let him finish my time.
My lord, as far as my contention is concerned, if your lordship kindly have the constitution, my lord.
Yeah.
Article 229. Appointment of officers and servant of a high court shall be made by the Chief Justice of a high court or such other judge or officer of the court as he may direct. Provided that the governor of the state may by rule require that in such cases as may be specified in the rule, no person not already attached to the court or shall be appointed to any office attached to the court. We are not concerned with the proviso. We are concerned with sub-article 2 mil. Kindly see, the article 229(2) itself starts with the word subject. Subject to the provisions of any law made by the legislature of a state, the condition of service of officers and servant of high court shall be such as may be prescribed by the rules made by the Chief Justice of the High Court or by any other judge, etc., etc. So, my lord,
About
Article,
233.
yes. Now please come to 233, my lord. Any person not already in the service of the union or of a state shall only be eligible to be appointed a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by High Court for appointment. My lord, at some point of time, there was a controversy as to any service with the state or central government means which appointment. Over a period of time, my lord, that controversy has been set at rest. Now it is only judicial appointment. Now the question is, eligible to be appointed. My lord, are we to give a literal meaning or we are to say eligible to apply? Now the service rule of the state says, on the last date of submission of application, I must be a practicing advocate of not less than 7 years' time, which I am. That is why, my lord, I participated in the selection process. I have been selected. I have been appointed, but I was not given the posting. Now, please take note of these dates, my lord. Advertisement for grade 3 was 1/2/24. 1/2/24 was the advertisement date for grade 3. Then 31/5/24 is the advertisement for grade 1. Then, my lord, 24/6/24 was the last date for submission of form, on which date I was not recruited or appointed to grade 3. 24/6/24, I was very much a practicing advocate having 7 years standing. Then, my lord, on 17/10/24, a petitioner was appointed to grade 3. 17/10. Then 19/3/25, I was appointed to grade 1. Petitioner joined on 23/25. Then, my lord, an impugned order was till that, my lord, I do not know why I have not been appointed. Why I have not been allowed to join. Because neither High Court has filed the affidavit, nor any information has been given to me. From the communications, what transpires is that my appointment has been withdrawn. Nothing beyond that. And in fact, my lord, I filed an RTI. I just prayed for the committee, Honorable Judges Committee's, my lord, report. Then, my lord, the High Court replies saying under 5D of the Right to Information High Court rules, I am not eligible for it. My lord, I am being appointed. Now I am being sought to be, my appointment is sought to be taken away. If I do not know the reason, how I challenge it, my lord?
Yes.
And my lord, when I moved this petition, an observation was made by the then Honorable Chief Justice that I have not informed the authority regarding my participation in the grade 1 selection. Now please come to page 23 of the, my lord, IA. Page 23. Page 23.
Yes.
I address this communication to the learned district judge, my lord. With due respect and reference to the above mentioned subject, I would like to request you to grant me casually for the period from 2011-24 to 23-11-24 for appearing in the main examination of grade 1 of Mizoram Judicial Service to be held on 22nd and 23rd of November. Now kindly see on the left hand side allowed. How High Court says, my lord, I have not informed. This is regarding appearing in mains, my lord. Then at page 24, when I was called for interview, then also I took casual leave. My lord, if your lordship would kindly have the judgment of this Dhiraj More, এখন দিয়কচোন। আছে নে কিতাপখন?
2020.
লৈ লোৱা। 2027 SCC 401. আছেন নাই? Well, this is the judgment which High Court seeks to rely. Kindly come to page 414, my lord. What are the facts? End of the day, judgment is an authority for what it actually decides. Every observation, every sentence in a judgment is not ratio. A division bench of this court has referred the matter. The question involved in the matter is the interpretation of Article 233 of the Constitution as to eligibility of members of the subordinate judicial service for appointment as the district judge as against the quota reserved for bar by way of direct recruitment. The petitioners who are in judicial service have claimed that in case before joining judicial service, a candidate has completed 7 years of practice as an advocate, she shall be eligible to stake claim as against direct recruitment quota. Is it the facts here, my lord? Now, my lord will kindly come to para 6. What was the question before the Supreme Court? Para 6 at page 416. Yep. The main question for consideration is the interpretation of Article 233 of the Constitution of India, and based upon its interpretation, question concerning rules being ultra vires of the same has to be examined. Because, my lord, the rules of the Uttar Pradesh, Delhi and all prevented the judicial service officers from participating against that quota. Now, my lord will kindly come to para 48, which is sought to be relied upon by the High Court, and also have para 45 and 46 at 444. In view of the aforesaid discussion, we are of the opinion that for direct recruitment as district judge as against the quota fixed for advocates, pleader, incumbent has to be a practicing advocate and must be in practice as on the cutoff date, and at the time of appointment he must not be in judicial service or other service of the union or state. For constituting experience of 7 years of practice as advocate, yes. For constituting experience of 7 years of practice as advocate, experience obtained in judicial service cannot be equated, combined. An advocated pleader should be in practice for immediate past of 7 years and must be in practice while applying on the cutoff date fixed under the rules. And this is the line, and should be in practice as an advocate on the date of appointment. Yes, my lord. In the facts of this case, it has been said. Why? Please come to para 47. In view of the aforesaid interpretation of Article 233, we find that rules debarring judicial officers from staking their claim as against the post reserved for direct recruitment from bar are not ultra vires. Now, my lord, I am not in judicial service. I am not seeking a declaration that I should be made eligible as an advocate under 7 years. But the Mizoram rule says, as on the last date, I should be a practicing advocate of 7 years standing, which I am. An advertisement, and now the fresh advertisement has brought in that additional criteria, which means that earlier now the rules of the game cannot be changed midway.
47.4.
Yes, my lord. For the purpose of an advocate has to be continuing in practice for the cutoff date. No, my lord, lordship will kindly, my submission is, this is a judgment rendered in the facts of this case. What are the facts of this case? Here the rules did not allow. Whereas in our Mizoram rule allows. Now, my lord, the rules have been framed for what? To effectuate the purposes of Article 233(2). Now, we have to give some meaning to the rules. So, my lord, this 47.4 is not a ratio decidendi to be covered even in a case where rules permit. It is a judgment in the context of the rules which was, being examined by the Supreme Court. Anyway, my lord, this is an aspect lordship will take a call at the time of final hearing.
Yes.
Now, I having been selected, appointed, now, my lord, my appointment has been put on hold. That is under challenge. Now, a fresh advertisement has been issued whereby, my lord, not only my post and another post has also been advertised. So, therefore, my submission is there are arguable issues, my lord. It may go either way. I'm not saying what I am saying is correct. It may go either way, but supposing if I succeed, then my success should not be, my lord, without some benefit, corresponding benefit. So that can be, ensured only by giving some interim relief, either in the form of one post should not be filled up, or, my lord, whatever selection is made, that will be subject. In any case, that ensues, my lord. How can my learned friend object to that?
That is
That's my
reflected in the judgment, advertisement itself, my lord. My lord, your lordship can.
No, my lord, why I'm saying so? Because in the advertisement, they have taken note of one existing and one anticipating. That being the position.
My lord, your lordship kindly see it is not the interpretation of, my lord, any rules. Your lordship kindly, this is the judgment which has placed, my lord. That is the, my lord, that's the reference made to the larger bench. Your lordship kindly see made the original judgment. What is the reference? Whether the person were eligible for appointment on the date of appointment, my lord. So your lordship kindly see this is the reference, my lord. We are not interpreting, my lord, any law regarding, my lord, this state rules, my lord. It's the reference was made only 233 Constitution, my lord. Whether a person at the time of eligibility will count it, at the time of, my lord, appointment, or at the time of filing, my lord, application, my lord. See, your lordship kindly see, that is the only crux of the matter, my lord. It is not an interpretation of any rule, my lord. It is an interpretation of 233, my lord, of the Constitution, my lord. And now, my lord, your lordship kindly see the 45 of, my lord, other judgment, my lord. So there is a bunch of cases all over India, my lord. Your lordship kindly see that 2020 paragraph 45, my lord. Paragraph 45. Paragraph 45. My lord.
Yes.
Very clearly, my lord, that he must be a advocate at the time of appointment also. So admitted fact is that, my lord, when she was appointed, my lord, she was grade 3 officer. That is admitted position, my lord. So from that point of view, there is no prima facie case, my lord. So since there is no prima facie case, there is no any, my lord, interim order. Yeah, now another thing I have to be pointed out. Your lordship kindly see the advertisement, my lord, which is, my lord, annexed in the, my lord, miss case, my lord.
Yeah.
This is the advertisement. This is started from, my lord, page 14, I think. Page 14, my lord. Last para, my lord, last line of the, my lord, advertisement is page 30, my lord. Sorry, page 20, my lord, page 20. The wrong mark, my lord. Last, my lord, as your lordship goes, page 20. The result of the recruitment process shall be subject to the outcome of the any litigation or is if so pending. Already protection is there, my lord. So my submission before your lordship, in the miss case, my lord, there is no, my lord, since there is no prima facie case, my lord, no interim order can be passed.
Yes, Chowdhury, you are protected.
No, my lord, just one thing, my lord. My learned friend is repeatedly relying on the judgment. For a moment, for my satisfaction, lordship will kindly come to the first part of the judgment at 414. Now, what all are the cases which were before the Supreme Court? Whether our case falls in that? Kindly see, my lord. There was a reference, I'm reading from the first sentence. The question involved in the matter is the interpretation of Article 233 of the Constitution as to eligibility of members of subordinate judicial service for appointment as district judge as against the quota reserved for bar by way of a direct recruitment. Well, I'm pausing here for a moment, my lord. Here is a case where on the last date of submission of application, the incumbents were in judicial service. They wanted that they should be treated at par because subsequent reading will reveal that, my lord. Kindly, now let me read further. The petitioners who are in judicial service have claimed that in case before joining judicial service, a candidate completed 7 years of practice as an advocate, he shall be eligible to stake claim as against the direct recruitment quota from the bar, notwithstanding that on the date of application appointment, he or she is in judicial service of the union or state. Now, the contention was before being in judicial service, they have been completed 7 years. On the date of application or appointment, they should be given. Now, kindly see. Yet another category is that persons having completed only 7 years of service as a judicial service, they contend that experience as judge be treated on par with bar service. They contend that experience as judge be treated on par with bar service, and they should be permitted to stake their claim. Third category is a hybrid consisting of candidates who have completed 7 years by combining experience serving as judicial officer and as an advocate. Well, none of the category which were considered by the Supreme Court is, visualized in the present case. That's why I'm saying, my lord, end of the day, it's a case which needs to be gone into. Prima facie, my lord, if tomorrow a third party right is created, then, my lord, there will be a multiplicity of proceedings. That's why I'm saying. It's good of High Court that they have taken note of a pending litigation. But then, my lord, in an appropriate case, lordship do protect the rights of the litigants.
No, but then the protection is already there.
Then lordship will say in terms of the protection, my lord, same observation may be made here.
No. Okay.
Lordship will maintain that.
Yeah, we are referring to the
Yes.
para
Last para of the
last 18, I think.
Clause eight.
Para 18.
My lord, well, deep look.
Number 20.
Item 2.
So
May please your lordships. One of the petitioner, he was serving as a in a venture ME school since 1987. When the school was provincialized in 2013, he was left out. He therefore approached this honorable court, challenging the provincialization of another person and claiming his provincialization. That writ petition was disposed of. If your lordship comes to page 38, that is the order in the earlier writ petition. There, your lordship may kindly come to page 42, the operative part. His claim was rejected. However, there an observation was made, page 42, my lord. But however, for the purpose of provincialization as the Assam Venture Educational Institutions Act 2011, in short, has been declared ultra-virus by the division bench in WPC so-and-so, and the subsequent Assam Education Service of Teachers Reorganization Education Act 2017 has been enacted in the meantime. The respondent authorities may consider the case of provincialization of the petitioner under section 13(6) of the Act 2017 if otherwise petitioner is eligible. So, my lord, that was the observation made. My lord, when the matter therefore came before the Director of Elementary Education, my lord, without referring to the district committee, he
what is that,
himself, my lord,
education manual.
if your lordship kindly takes up the rules.
It's it, right. 13(6), isn't it?
My lord.
13.
Page 122, your lordship will find the, my lord, 13.6. 13.6 and 7, both will be important, my lord. The district committee, may I read it, my lord? Page 122 in that book. The district scrutiny committee shall first scrutinize and prepare a list of all venture educational institutions. Right.
Yes.
So, my lord, under, my lord, section 13.6, the matter has to be placed before the, my lord, district level committee. But the, what the, my lord, director did, he, my lord, himself took upon the responsibility and rejected my claim. So against that, my lord, I filed the writ petition
You are a teacher out?
of a ME school, man. Then the director, my lord, rejected my claim that your lordship will find at page 43, my lord, without my grievance is that, my lord, it has to go to the committee. The director himself, my lord, cannot.
See, rule 3,
Rule
311.
Rule 3 is regarding, my lord, eligibility criteria for selection of education institutions, my lord. Now, what happened, my lord? The matter was already placed prior to, my lord, provincialization. It came up before the, my lord, scrutiny committee. And the scrutiny committee, my lord, whatever the report is there, only 3 persons were, my lord, provincialized. Although, my lord, there is scope that, my lord, other persons can also be, my lord, provincialized, more than 3 teachers.
You belong to which subject?
My lord, I am a higher secondary pass teacher,
Okay.
assistant teacher, and my lord, under the rules, he has to be given opportunity 5 years of acquiring his educational qualification. His grievance is limited to the, my lord, to the, my lord, fact that, my lord, his case was not placed before the, my lord, this state committee. And director on his own rejected it, man.
Yes. No problem. Here, let's have him place it before the district.
Therefore, that is the only prayer made that was before the honorable single judge, my lord, my lord.
Who's at the district? Okay. We'll examine this case. Heard Mr. M. K. Chowdhury, the senior counsel. Assisted Mr. N. Sharma, the counsel for the appellant. We'll admit it. We'll have Majumdar, you are appearing for? Mr. R. Majumdar, the standing counsel, school agent.
He'll appear for all the applicants.
I appear in 5 or 4,
Appears on behalf
1
of
to 4.
1 to 4. You'll state
the respondent. 1 to 4. How about the 5? And MS? S. Sharma, Leonard, government advocate. Appears for the respondent of friend. Oh. When shall we have it?
Immediately on the reopening.
Will it be in July?
On the reopening. After summer.
List after the summer vacation. For admission.
God bless.
God bless you.
I'm free.
One of the submissions made and the grounds taken, in fact, submissions have been recorded from paragraphs 4, 5, and 6. That did not receive any consideration. There's a very interesting question of law that arises. Normally, under normal circumstances, an order granting prosecution sanction can be questioned during the course of trial. But when there is a prima facie case, and clear case of violation of Article 14, will even then your lordships have a hands-off approachment. And those issues I have raised in fact, my lord, that was I am fully conscious of my lord, the law otherwise. But the contention was, my lord, if your lordship will kindly come to para 4 of the judgment, page 24. Para 4, 5, and 6 were the specific contentions. Mr. So-and-so, for the petitioner submits that the impugned prosecution sanction in respect of the petitioner is challenged primarily on the ground that several aspects that were considered to be germane and relevant for declining the issue pertaining to according prosecution sanction in case of the two other main co-accused were entirely ignored in case of the petitioner, thereby vitiating the entire decision-making process. He further submits that the 3 charge sheets in respect of the petitioner and the other 2 said co-accused persons indicates that they were identically worded except for a few facts and figures. However, though the prosecution sanction in respect of the other 2 accused persons were declined, prosecution sanction in respect of the petitioner was granted. He further submits that the protection guaranteed under Article 14 of the Constitution of India has been violated with all impunity, particularly since various relevant considerations in case of the petitioner, such as brief tenure in the post of in-charge video as additional charge having been made to serve against his will, primary responsibility of the principal secretary and project director of implementation of so-and-so, assets and liabilities not being disproportionate to known source of income, and most importantly, the opinion of the learned advocate general Assam were entirely ignored. These were aspects which formed the basis for declining in respect to the others. He accordingly submits that the hostile discrimination has been meted out to the petitioner. He further submits that in the affidavit in opposition filed by the state respondents, there is no explanation whatsoever as to why such germane and relevant considerations were ignored in case of the petitioner. In support of the aforesaid submissions, he relies upon the following decisions of the apex court. The next parameter, para 5, in support of his contention that this court under Article 226 of the Constitution can judicially review the legality and validity of the prosecution sanction order, he relies upon the following decisions of the apex court. And thereafter, para 6, further, by placing reliance in the decision of the apex court in the case of so-and-so, he submits that the constitutional power vested in the High Court cannot be fettered by any alternative remedy available to the party concerned, and such constitutional court can strike down injustice whenever and wherever it takes place. These are 3 specific contentions. Or if your lordship looks at the judgment, these aspects did not receive any consideration at all. And in fact, all these judgments cited, with greatest respect, they have not even been discussed. At this stage, I am praying just for a notice, let them respond if they have to. Your lordship will examine.
Most humbly draw your lordship's attention to paragraph 11 of the judgment review, page 31. May I read it out, ma'am? Reading of the aforesaid averments in the affidavit in opposition, it appears that the stand taken by the respondents in the said affidavit is that the prosecution sanction order dated 6/7/2013 was issued against the petitioner after careful examination of all records and with due application of mind, it further appears that the petitioner at the relevant period was holding the post of a BDO of the Doon Valley Development Block and was functioning as program officer with effect from 8/2/2006 to 7/7/2007, and that he was responsible for proper implementation of Menrega scheme, etc. It further appears that it's the specific case of the respondents that it is found from the available records that the petitioner entered into a criminal conspiracy with his subordinate staff to misappropriate public money. It appears that the other two co-accused persons have served in the development block in question for a brief period of 2 months and 2 months, 25 days respectively. And considering such brief period of service, and also after scrutinizing relevant records furnished by the CBI, along with their assets and liabilities, criminal intent to earn wrongful gain, having not seen feasible, prosecution sanction against the aforesaid two officers were refused by the sanction. And also, my lord, as my learned senior colleague has placed before the honorable court, it is at the trial court that this issue has to be raised. That is the law as it stands. That's my answer.
Can we close the matter today?
Yes.
Your lordship is taking up for disposal. In that case, my lord, let me place some of the relevant materials based on which these submissions will be.
Then we'll take up on a hearing day. But Mr.
Date will be fixed
I-
for date.
Chowdhury, level senior counsel, assistant prime minister,
Yes, Chakravarti.
S. Chakravarti, level counsel, applicants. Also heard MS S. Sharma, level government advocate. For all the respondents?
Yes, 1 to 3.
For all the respondents. That's good. When do you want?
After,
Tuesday?
perhaps it has to go after the vacations. 24th, madam. On a hearing day.
Want it on 24th?
If you,
Okay, list the matter of 24th July.
24th of July.
July. For it. Just one more thing.
Item 4 to 6.
Also, may I please after some time ago. She will try lordship otherwise. After some time ago.
Yes.
Lordship 7 made the matter may be taken up on Monday because I don't like to appear. It will be not proper because the
One
response of the
request
discussion
made by
happens to be my
Mr. P.
classmate.
Chakravarti, Leonard CGC.
Let it come on Monday, like.
It's the matter on 16, I think we fixed many. 18th. 18th.
Public. A.
Lordship, my senior is on legs, Lordship.
Let it be in a hearing day so that it will be heard. In fact, one of the same issue regarding second service pension. Some of the high courts has passed order against it. Accordingly, we opposed the Supreme Court. The matter has been stayed. And the issue is for the some time because
Okay. Heard UK Goswami, let's see this, what happens for the petition. Who's your senior?
AR Tabitha.
On request whether we have of air tablet, then the council for the sole respondent. When? 2 weeks? After 2 weeks.
Hello.
Item 9.
Lordship, this has been filed because Lordship, the other side is pursuing the contempt and the tribunal has asked the either you bring stay order or we comply with the order. That's necessitated, Lordship. Otherwise, notice has been issued long back. Other side has filed the counter also,
Ah.
Lordship.
But then notice is complete.
Yes, he has appeared. He has filed counter also, Lordship. The fact of the matter is that Lordship,
Counter is
While-
there?
Lordship counter has been filed.
Yeah, respondent number one. How many respondents are there?
Only one. Likely to be filed on 17th March, Lordship.
Who appears?
Mr. D.N. Sharma.
We'll see. When is the contempt listed?
Lordship, it's on Monday. The tribunal is allowed of the record, Lordship, the amount may be high. That can be interfered with. Otherwise, Lordship, he alone has not been punished, Lordship. Other person who has made recovery of other persons also. Lordship.
That will consider. We'll take about Friday, no point in waiting. But Mr. B. Chakravarti, the CGC. None appears for the respondent. List again on
Friday, Lordship.
13th.
Item 4 to 6.
Gautam here notice only will have to go.
Lordship. Senior was inclined to the case, Lordship, may pray for tomorrow, your Lordship. Short matter, otherwise done.
Friday,
Friday, Lordship, from difficulty, Lordship, tomorrow, Lordship.
Monday then. Monday.
Lordship, level on 17 then, Lordship, because 13 and 16 days some difficulty on our part, Lordship.
13th then.
16 days some difficulty on our part, on 17 then, Lordship.
17th. Okay, on request made on behalf of Mr. Ken Chowdhury,
Ken Jordan.
the senior counsel for the appellant. List on 17th.